opposing counsel to very soon. So
Yep.
straight stars to where the.
No, you can, yeah, if you'll just sit right here, and you can see him. He should be able to see you when you're in the photo. All right.
Sorry? Is my turn? Yeah, he's the guy who likely does our trials. Probably.
All right. The Court of Appeal in the 46th District of the State of Florida is now in session. The Honorable Jared E. Smith, Judge presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America and the state of Florida and this honorable court. Please remain standing for the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good to see you. Good morning, everyone. We're going to do some quick introductions here. Can everybody hear us online okay?
Yes, Your Honors, I can hear you quite fine. Thank you.
So let me just make some quick introductions before we get started. I am Judge Jared Smith. I'll be presiding today, managing the clock. And to my right is Judge Joshua Mimes. And to my left is Judge Richard Orfinger, and we're very thankful to have him. So our first case today is 23-341, Allstate Construction Roofing Inc. versus David. And I'm probably going to get this wrong the first time I say it. Is it Schimmelpfennig and DNS Adjusting? Is the P silent? I guess is the question I have. That's probably the question I'll have. That'd be the first question. Get that done before we have to take up time. Is that, did I say the last name right? Is it Schimmelpfennig?
Yeah, you actually nailed it, Your Honor, which took me 2 years. So,
All right. So with that, let's see here. Whoever's representing Allstate, let me step up.
Good morning.
All right, good morning, counsel. And before you get started, counsel, if you would mind telling us how much you want to reserve for your rebuttal.
5 minutes.
Okay, perfect. Everyone ready? Okay, we'll go ahead.
All right, may it please the court, my name is Jonathan Wire. I am the counsel here on behalf of the appellant in this case, Allstate Construction Roofing Incorporated. I'm going to be referring to my client as Allstate throughout the presentation I'm giving here today. I'm going to be referring to the plaintiffs' appellees just as appellees because I too have difficulty pronouncing the name of the who is the one of the appellees here. This is an appeal that occurred after a jury trial. There were a number of objections to issues that were raised at trial, both on evidentiary grounds and on argumentation that we raised in the brief. We're asking that this court reverse the final judgment below that was entered as a result of that verdict and enter judgment in Allstate's favor because we believe that at least 2 of the major categories of issues that we've raised on appeal require reversal as a matter of law and entry of judgment in Allstate's favor. Alternatively, we believe that both of those grounds, in addition to some of the other grounds that we raised towards the end of our brief, warrant vacating this judgment and ordering a new trial. Before I begin with those arguments, though, would the court like me to give a brief recitation of the facts?
Well, let me do this, counsel. We have been discussing this case, and I know there's a lot of ground we're going to cover on this. So I may just jump right in with the question, and I suspect my colleagues may do the same. One question I have is there's an assertion that you've made in your appellate brief that there was a lack of sufficient evidence in relation to the damages. And my reading of your argument is that because the plaintiff did not have the specific costs, actual costs for every roofing job, therefore we don't know what the net profits were. And my question to you is, in reading through the transcripts, it appears that he states, and this is up to the jury gets to accept this or not, that the $650 per square is what he calls the maximum price per square. Is there any case that says that a party opponent admission cannot be used as evidence to establish damages?
Okay, so my response to that question is severalfold because there's 2 different layers here. To address specifically whether this is an admission, I don't think on this record we can call this an admission of any kind, and the reason for that is because the plaintiff himself testified that he was not sure as to what this was. I'd like to direct the court to the fact that on page 260 of this transcript, of the trial transcript, Mr. Schimmelpfennig testified that this $650 per square was a minimum cost per square. Later on in testimony and in closing argument, his counsel said that this was a maximum cost. On cross-examination at page 400, 399 to 401 is where the sequence occurs. Mr. Schimmelpfennig testified that it's an average cost. He also testified that this was a estimated cost for when folks in the field are estimating the total cost of a roof in order to provide a contract or to actually seal the deal with the homeowners. It's not even $650 is not the actual cost. He admits later on in cross-examination, if I can, I just read the court what he says. For any of the jobs, I'm reading on page 399, starting at line 21. For any of the jobs for which you're seeking a commission on, do you know what the actual job costs are? On some of them, yes. Which ones? I'd have to look that up. How would you look that up? On my documents? What documents? From the AccuLink system. Okay, is there anything here that you could look up and tell me what the job costs were? Here with me? No. Moving on down. If I go through the entire list, this is the attorney asking the questions about the 22 jobs. Is the answer going to be no as to the actual cost after these jobs are already completed? The answer, yes. And then further down, without knowing those actual costs, you have no idea what the net profit on a particular job is, do you? Answer, not the exact dollar amount, no. I can be within a few percentages from looking at it. So again, I think it is I don't think that we can call this an admission. Even if you were to presuppose that my client, and there was no testimony on this record or evidence of this, that my client said that the job cost would be around $650 per square. We have the testimony of the plaintiff himself saying.
Counsel, if there's testimony pointing in different directions, that doesn't mean there's not enough to create a jury question. It means there is a jury question. It doesn't sound like you're saying it's not an admission. It sounds to me like you're saying it wasn't specific enough. But, there's a broad evidence rule on damages. And if there's conflicting testimony, even from the same person, jury can say, hey, I believe that guy. I don't believe that guy. I think he's telling the truth. I think he was, his mind was fluttered there and he didn't know, maybe he was, had a moment where he had a lapse in memory, but he said the right thing here. And I find that's what a jury does. They sort through all that.
Understood, Your Honor, but in this case, that's not what he's saying. What he's testifying to is he's saying when we go out in the field and we make a determination of how much this roof going to cost, this is what I believe we were supposed to use as the value. And again, he doesn't say, it's not a lapse in our judgment or a lapse in what we're saying. It's his own testimony saying this is an estimate of what we would go out and estimate the cost to be. This is all the way back in 2018 or 2019. These projects were not completed until years later. You have to have the documents. I would also want to point out too, that the contract itself between the parties has a specific formula as to how you have to break down these actual job costs, what kind of overhead you have to attribute on the project, and that all goes into the calculation of how you calculate profit. So what we're saying to the court is that on this record, there is no evidence of what these actual job costs would be. All we have is some back and forth testimony as to what an estimate and an average cost might be in his experience. That's not actual job costs. Mr. Schimmelpfennig could have had the opportunity to present that evidence because he says it's in the AccuLink system. I just read you that transcript, but he never actually did that. And this is
Counsel, let me just jump in.
Yes, sir.
And I don't know that I disagree with my colleague on this, that if you've got conflicting evidence, if you've got a witness saying left and then later right, then when you appeal it, that you get to choose the left answer rather than the right answer. We clearly, we go by the record. We're stuck with the paper. The paper says on record transcripts, page 432, okay, they said their cost would never be above $650 per square, correct? I mean, to me, is it an admission? Is it not an admission? Is it conflicting? Is it not conflicting? My question to you is, did you do anything in the trial to show that this was not an accurate statement? Did you present any evidence to say, well, here's one job that clearly shows this is not right. Here's a job that costs $1,000 per square. Was there any evidence like that in the trial?
So, Your Honor, respectfully, this was an argument that was also being made constantly by appellee's counsel that, well, we're claiming it's this, and they're not coming out here and trotting out a bunch of evidence to disprove us, therefore it has to be this. And that's an argument from silence. It was not.
It's not an argument from silence, counsel. It's an argument from admission against interest. That's in the evidence code. It's an exception to hearsay. It's evidence.
But again, this is not an admission. I just read you the transcript.
Well, you read me part of the transcript, and I think Judge Smith just read you part where he said, this is the maximum. And at least one place, he said, this is the maximum. Now, in other places, maybe he said things that confused it more. When you have testimony that is unclear, multiple pieces of testimony, the jury sorts through those. We just say, is there something the jury could have locked onto? Is there something they could have said? Is there something they could have accepted? I think Judge Smith just read you a line where he said, they told me this was the maximum cost. The jury looked at that and said, yeah, I believe him. I think he's telling the truth. I think he was confused the other times, but there's an admission and they didn't conflict it. You got admission against interest. You have other conflicting testimony. Jury can look at it and say, we accept it, can't they?
I disagree in this case, Judge, because of the type of damages we're talking about. We're talking about lost profits, and the threshold for getting a lost profits damages award or assessing lost profit, it has to be concrete. It can't simply be, well, somebody told me, and again, the record is pretty clear that these are estimates. These are not the actual costs.
Lost profits are almost always based on estimates. If you had the actual profits and you knew exactly what they were, you wouldn't be seeking lost profits, right? When you are trying to establish lost profits, by definition, you're trying to estimate a number that you don't actually have.
However, in this case, we can actually find the lost profits if they would have taken the time to present that evidence to the jury. But that's not what happened here. Instead, what they decided to do was come up with a number. I don't know where that 650 number comes from other than from his side of it. And then just basically say, well, we've done our job. We've said that they said this at some point. It's an estimate of an actual cost that comes in when we make the estimate for the roof.
Council,
We're not going to go through and tell.
I know we can, I've got kind of a different question, but I think it is related to this. If your company would have wanted to use an estimate, could they have? For all your sales contractors that are out there, for all your commissioned salespeople, if your company Allstate wanted to use an estimate for the square price, could they have done it?
They certainly could have, but we're talking about how this person is going to be paid and the contingency.
Why could the company do it, but the individual salespeople not be able to do it?
So are you saying that if it was written in the contract that we're going to estimate ahead of time what the actual costs are going to be, you have to live by that?
My question is, could Allstate, if they wanted to, on this contract, could they say, we're going to estimate what the costs are on a job?
No, they would have to, on this contract, they would have to go in and they would have to determine exactly to the penny what the actual costs were, both for materials, labor, calculate their 10% overhead over on top of that.
But doesn't your contract say the cost of labor and the cost of materials will be determined by the company in accordance with that is the company's generally accepted accounting practices? Isn't it a generally accepted accounting practice to estimate? Don't people do that all the time when they're accounting?
Not for actual costs, Your Honor. That's an actual dollar value. That's a check that's being written to a laborer.
Where does it say actual costs in this paragraph? I'm looking at Exhibit A.
Yeah, I apologize, Your Honor. I misspoke if I said actual cost being in the contract. It does say cost. However, I think if you read the paragraph, it's clear that it's not talking about an estimate of the cost. It's,
Counsel, let me ask you.
Yes, sir.
Switch gears for a minute. I want to talk about what the contract requires Mr. Singleton Finnick to do. And it seems like there were 3 phases of his work: sign the agreement, turn in the job, build and production, and collect.
correct.
I want to take those in reverse order.
Okay.
Was there any evidence introduced at trial by either side that he did anything to collect, with the exception of the 3 homes that apparently weren't in dispute? With regard to the other, I don't know, 20 or so, whatever it was there any evidence on either side that he did anything to collect the payments?
The evidence was uniformly and without any conflict that he did not. In fact,
Was there any evidence that he participated in the build or production side of things?
the evidence was he did not.
And there was some evidence, as I understand it, that he signed up a lot of clients.
Correct.
Is it your contention that when you use the term turn-in job, that's defined more clearly in Exhibit A as far as, the Xactimate and all the others, the drawings, the Eagle View and all that? That's what a turn-in job is?
That's correct, Your Honor. It's both Exhibit A. There's also testimony both by Mr. Schimmelfinnig and also our clients as to additional items on a check that have to go into completing your turn-in phase.
Well, but do you agree that the checklist isn't part of the contract? If we just focus right on the contract, and that's what I'm focused on, is what does the contract require?
Yes.
is it your contention that Exhibit A defines what turn in the job means? He's got to do these 4 or 5 things.
Yes, it certainly gives a non-exclusive list of everything. So, but for instance, down.
What effect does it have if he's about to walk into the front door of Allstate with the Xactimate in his hand and all of the other things that would encompass the turn-in under Exhibit A, and your guy walks out and says, "You're fired." I mean, clearly they're right to fire him right on the spot. But does that failure, I mean, if that were to happen, he was prepared to do it, the jury found that he substantially complied with the contract. Is that enough to demonstrate at least that he complied with that first phase, that one that would entitle him to at least a third?
So, Your Honor, I think the testimony at trial was that he did not complete most of the items that are actually on this contract, including the Xactimate, the Eagle View, work orders, insurance paperwork. His testimony was primarily that he signed up the homeowners, and he felt that that was all that was substantially required. There was an additional checklist of items that he said that Allstate was pushing on him that they had to do. But the testimony itself, and this is from his deposition and also at trial as well, reading page 441, for instance, the trial transcript goes through it, was that he did not complete even what was on this contract document. What the jury ended up doing was, this is part of our issues on appeal, was that this contract was not construed for the jury as far as what are the requirements of the contract. The jury was just permitted to decide what the requirements would return in. And they said, well, we think that what you testified to is substantially compliant.
Did you ask for a jury instruction on that?
We did, Your Honor.
Yes, but that's not an issue on appeal, is it?
It is, Your Honor. That's one of the issues that we raised in our brief. I believe it's in section 2C. If I'm not mistaken.
Counsel, kind of following up on that, you have to,
Just, so you are into your rebuttal time at this point.
I'm happy to answer your question, and then I'll wrap it up.
yeah. So you have the duties set forth, and I think it's paragraph 5 of the contract, and it says sales and marketing services. Then you go to Exhibit A, and it doesn't say additional duties, it says compensation schedule. The word schedule to me seems to me, when you're gonna get paid. Okay? Then you go down to the part you all focused on a lot, it says duties included but not limited to, right? And then it says selling, building, and collecting. And then it gives 3 items, sign agreement / turn-in, build / production, and collect. And it says, since all tasks are weighed equally at 1/3, failure to perform any of these tasks may, not shall, but may result in a reduction of applicable commission for the amount of 33% per item. What do we do with that when the only actual kind of service listed was sales and marketing? And then these duties gave some kind of discretionary right that doesn't really say how it's exercised or even who exercises that right to reduce his damages. And then you go to the verdict form, and the jury, there are specific findings on each of those 3 things. So for each of the jobs, the jury found he did the sign agreement, he did the bill production, he collected the verdict. The verdict form to me, an interesting word is earned, right? It didn't say did he complete these things, it said did he earn the commission, right? Which kind of tells the jury may have been looking at this May, and it may have been looking at the breach of good faith and fair dealing, and all these things came together, and they just said, we think you earned this.
Yeah, I think that there's several things here, and I don't want to go over too much on this, but the issue here, though, is that if there is such a thing as a discretionary act, it's only one way. And what I mean by that is that if while the person is employed, if they fail to perform certain of these things, we may elect not to pay you for what you have not
That's not what it says. It does not say we get to choose, or we in our sole discretion.
Yeah.
It says failure to perform any of these tasks may. Doesn't say who decides, it doesn't say your client gets to decide.
Understood, but it would be my company paying.
And it would be him demanding,
Correct.
right? Like it says may. It doesn't give any standard for how you decide that.
It does, because it says that if you fail to complete the task, it will result in a deduction of the applicable commission for the amount of 33% per item. So if you fail to do task number 2, for instance, then you would you would not be eligible for that.
I think that argument would be better if it said shall instead of may. It says may, implying something that could happen or some discretion without saying who exercises that discretion or by what standard they would exercise that discretion.
Sure.
Right? And if the jury finds, hey, there was discretion here and it was exercised in bad faith, that's breached the good faith and fair dealing.
But that's not what was found, and that wasn't the issue of discretion that was being argued, if at all. In fact, I don't believe that the issue of discretion was ever brought up as being an issue for this contract. I think that the whole argument that the appellees made was that they fully performed, or at least they substantially earned what they were entitled to, which was the entire amount of the profit. That was not something specific that was ever argued or considered. And also the reason being is because he was terminated before completing any of these items. So this isn't a situation where he's still employed. My time is expiring, Your Honor. And so very briefly, I just would like to again ask the court that you reverse this judgment. Judgment should be entered for Allstate in this case. And at a bare minimum, based on everything else that was stated in the brief, a new trial should be ordered. Thank you.
Okay, and counsel, I'm going to go ahead and give you a couple of, because we held a few questions here at the end. I'm going to give you a couple extra minutes for rebuttal, but I will add 2 more minutes if you need it to your opposing counsel.
Thank you, Judge.
Thank you. All right, 1 second. Okay, counsel, you may begin.
Yes, good morning again, Your Honors. May it please the court, David Fraser for the appellee. I do appreciate the Zoom appearance. It definitely eases in the practice of law, and I do appreciate that, Your Honors. I will start off with Judge Orfinger's point to the contract. The contract says that the contractor shall provide sales and marketing services in the areas of roofing, siding, gutter restoration, and repair. The big argument below was whether this list of job duties that was not part of the contract somehow defines the contract, right? That's a factual question that the jury determined in my favor, that we complied with the actual text of the contract.
1 second.
Do you agree that I don't know which microphone you're talking? Do you agree that Exhibit A is part of the contract? I'm not much concerned with the list that they gave him, but Exhibit A is.
Right, and that's exactly where I was heading, Your Honor. Exhibit A is part of the contract, but Exhibit A is a payment schedule, number 1. Exhibit A, the terms of their non-payment, it includes a may, which is a discretionary act which must be applied in good faith under Florida law. And under Exhibit A, I actually went through that in trial because one of the things that Exhibit A constitutes, it says you have to pick up the checks. That is something that everyone in this courtroom knows, that a salesperson cannot go to the adjuster and say, I'm here to pick up the check. All of these cases were in litigation, right? They're all products of settlement and they were all paid. So we actually called the attorney for Allstate who came and testified that not one salesman ever picked up the insurance check, right? And we all know that. And it was explained to the jury that a salesperson can't show up to the desk adjuster's office and get the check. So they're saying, according to Allstate, they're not paying him for something that they couldn't do. And also, we also had testimony, we put in the message from Allstate representatives that said, under no circumstances, and it was no, and I mean no, this is record 1996 through 1997. I do not know how to say this any clearer than we already have. Under no circumstances, and I mean no, capital letters, are you supposed to send any information to the insurance company? Do not send or work with any desk adjusters. Again, how is my client supposed to go pick up a check when they're clearly telling him not to contact them? So again, I go back, this is a payment schedule. I go back to the contract language. The jury found my client performed those things. We also talked about build and production. In the record, they actually have a production manager, and I just wrote that on page 504 of the trial transcript. The production manager manages the build. I walk them through, does he have the ability to?
So looking at this Exhibit A, which is really, it's the part of the contract I am having the hardest time navigating. Second page, it says a sales representative kind of broken English. It just says number 1, 2, 3. Representative what? Sales representative, colon, 1, sign agreement / turn a job. 2, build production. 3, collect. Does a sales representative ever build anything as part of their job responsibilities? They ever swing a hammer and nail? Do they do any of that?
No, never. But
Do they produce anything? Do they produce any shingles? Do they produce any product? If they're required to make anything at their house, what production are they doing?
nothing. And we asked that in trial. We asked them, do they dictate code? Do they swing hammer? Can they alter projects? And it was no, no, no. What are they expected to do? Well, they're just supposed to be there in case someone needs to change a tile color or something. So it was the definition of a ministerial or perfunctory task that, again, if we're operating in good faith, we don't hold back someone's payment for not doing something they never had an obligation to do, right? They were never supposed to swing a hammer. The build production wasn't telling the salesperson to get on the roof and start tearing off tiles and putting new tiles on.
I actually agree with a lot of what you just said, but I think the word good faith there did a lot of work, because you're right, if there was some discretion in the contract, they had a right to fire him, but they have to, if they have discretion and whether they fire him, they have to exercise that in good faith. Right? That's what the covenant of good faith and fair dealing is. This is when you have discretion under a contract, you must be exercised in good faith. And if they purposely stopped him from earning commissions, that seems to me to be a really strong breach of the covenant of good faith. Problem is, I'm looking at your pleading, and they contemporaneously objected to this, and the breach of the covenant of good faith that you pled was defendant failed to inform DNS when claims were paid and never provided any accountings regarding what profits were realized by defendant, forcing DNS to rely upon public records to determine whether his commissions. All those things you mentioned seems like really strong cases for breach of the covenant of good faith and fair dealing. None of them were pled. And it seems like the argument made below was, when they brought that up, was, well, we incorporated all of our prior allegations. And that's true, but none of those prior allegations identified the breach of the covenant of good faith and fair dealing. None of them said this was what the breach was that you're dealing with. And they weren't told that until after the close of evidence. It seems to me like a lot of your case relies on they acted in bad faith. And it seems frankly that you proved that and that they acted in bad faith. Seems like you never pled it and never amended to change your, never sought to amend your pleading to, put forth the argument that you ultimately convinced the jury of.
Right. So if I could respond to that in two parts, and I'll come back to the principal part second, Your Honor. First, we've prevailed on the breach of contract claim, which the contract defines my job duties, and the jury found that I performed all of those job duties, and to the point that build and production, there wasn't anything for me to do, and collect, there wasn't anything.
Not find that you performed those job duties. The jury found that you earned commissions for each of those duties, okay? It doesn't say that finding is specific to the breach of contract claim. The jury could have found that you earned commissions because they acted in bad faith, right?
Well,
but if you plead a basis for them to find, the jury to find they acted in bad faith, all that goes away. Nothing in this verdict form says, did they complete these job items? It says, did they earn a commission? Right.
But the verdict form I did prevail on the breach of contract claim, which had jury instructions that required that.
Yes, but the specific findings as to each of those three items for which a commission was earned, none of that says, in the context of the breach of contract claim only, right, did he complete these three things? There's a question of, did they breach the contract? Did they breach the duty of good faith and fair dealing? And then were these commissions earned for each of these three items for each job, without saying whether that question of earning a commission relates to the breach of contract or the breach of the covenant of good faith. And I'm not seeing why a jury, seeing all these things together, could have said, just like you made a very strong case, yeah, they breached the covenant of good faith, therefore I'm going to find he earned the commission. Problem is, if you didn't plead the right claim for breach of covenant of good faith, that should have gone to the jury.
So, and I understand how the court is reading that the verdict form to kind of conflate those together or bring those together. But no, Your Honor, I didn't mean to cut you off, sorry.
No, go ahead.
My point is, I think it's a really good point. And if I was trying this case over again, I would definitely want those drawn out. But that wasn't raised by the appellant's counsel down below. So if there's confusion.
Failure to plead the breach of the covenant of good faith.
Okay.
They raised it, the trial court overruled them, and the only thing the trial court's, your argument and response was, yes, our breach of the covenant of good faith count did not plead that, but we incorporated all of the prior allegations. And I certainly see why that would have provided a basis for the breach of the covenant of good faith claims you've identified. Problem is, none of those allegations identified the breach of the covenant of good faith and fair dealing that you ultimately relied on to the jury. And then the jury returns a verdict form saying, yes, they succeeded in their claim for breach of the covenant of good faith, which the jury was misinstructed on, and B, all these commissions were earned, oh, by the way, after the jury has already found that they breached the covenant of good faith and the other side acted in bad faith.
Yeah. So I would get into I understand that, and I guess I'll just respond. I think the court understands my position on that, is I think that the breach of contract and the instructions would give me the same damages. But I'll respond to the pleading issue. The pleading rules require me to put the opposing party on notice of the claim. And here, in Florida, we are allowed to incorporate counts by reference. So all of those factual
Incorporated counts said what the breach of the covenant of good faith and fair dealing was that you argued to the jury. Not the basic breach, which count identified the breach?
So in paragraph 49 of the complaint, it says when a party to a contract promotes its self-interest as against the reasonable expectations of the other party who entered in the contract, the duty of good faith is applied. So I would submit to the court that they're on notice that
just defines the covenant of good faith and fair dealing counsel. Which paragraph in the complaint identified the breach that you ultimately argued to the jury? The breach you ultimately argued was they had discretion to fire him and they exercised that discretion in bad faith. Which count of the complaint identified that breach?
Paragraph 7, I said that in exchange for performing the contractual obligations, they should be paid. I said paragraph 11, they were terminated without cause. They should be entitled to be paid for, they were earned prior to termination despite not fully completed when the employer prevented him from completing the project, paragraph 14. So they prevented him from completing those items. So I would submit to the court that we did put them on notice of that. And
do any of those paragraphs say this is our breach of the covenant of good faith and fair dealing?
Well, I'll pull up the complaint, and I believe they're titled breach of good faith and fair dealing. So those, they're the count 3 and count 4 are breach of the implied covenant of good faith and fair dealing. And I say, the Florida law recognizes it. The covenant is intended to protect the reasonable expectations of the parties. The DNS is obligated to pay 40%, and I reincorporate all those things. So I think.
Let me ask you this: How can there? You say it's to protect the reasonable expectations of the parties, but if there's an explicit provision that allows them to terminate the contract at any time for any reason, how can that be a violation of the covenant of good faith? Both you and opposing counsel cite the Avatar case, which says that the covenant of good faith cannot be used to create a breach of contract on one party's part where there is no breach of any express term of the contract. So laying aside what he might have been able to earn up to the point of termination, how can it be if your argument is they fired him so he wouldn't earn this, how can that be a violation of the covenant if they have the express contractual right to do that?
Okay, yeah, I understand the question. So, and somewhere along the lines, the duty of good faith and fair dealing is now being argued that it must be equivalent to an express breach of contract. The duty of good faith and fair dealing is to require people who can do a discretionary act to do it in good faith. Like your Honor's example earlier, if he shows up, he walks in with all his paperwork into his employer and they say you're fired, you don't get any money. The duty of good faith requires them to come in and to exercise its discretion in good faith. Here, the testimony was that my client performed all the acts he could possibly do. He couldn't.
Hold on. Doesn't the Avatar case say just the opposite? That if the employer, in this case, if DNS had the absolute contractual right to fire him at any time for any reason, how can that be a violation of the covenant of good faith for them to simply exercise an express contractual right?
Well, I think there's a difference between allowing somebody to continue to work versus this case, paying somebody for work that was already done. Our argument that was that the work was already done. And there's simply these things that he wasn't going to do that triggered his payment, like collecting the check, which the attorney did. So
Is it your contention then that he fully performed, at the point that he was terminated, he had fully performed his obligations under the contract?
Yes, all material obligations under the contract, he fully performed them.
Okay.
And that was testimony in the record, and I asked him that, that he performed everything he was supposed to do. The appellant, and really my argument is one that's in the alternative. So if I were to lose that argument and the appellant prevails saying, look, he didn't perform everything, which is a factual question that jury found that, that was in the breach definition, that if we material perform, did we perform everything we were supposed to do, and did they not?
So, counsel, I think you answered. If you feel like you got a question answered, I think you answered his question, and I just want to jump in real quick. And this is probably something I'll ask both of you, since we've got a couple extra minutes with your opposing counsel. As I read the body of the main portion of the contract, minus these two exhibits that both have the title compensation schedule, which I'll talk to you about that in a second. As I read the main body of the contract, all 21 sections, the only section that I see that defines what the contractor is supposed to do is section 5. And the only sentence I see in section 5 that defines what a contractor is supposed to do, and I'll qualify this a little bit, is the first sentence, which says, contractors shall provide sales and marketing services in the areas of roof, siding, and gutter restoration and repair. Now, there's another sentence in paragraph 5 that talks about permits required, but that is very nondescript. There's really nothing else that explains, as we've already discussed, the work is actually done by Allstate, so I don't know anything about the pulling of permits, and that really hasn't been discussed much. But let's just say the first sentence there, sales and marketing services. That's what a contractor is supposed to provide under this contract. Is there any other section under the contract, the main body of the contract, that describes the services the contractor must provide other than sales and marketing?
Not that I'm aware of, Your Honor.
Okay, so
Counsel, let me just jump in. What is the impact in the third whereas clause on the first page? Doesn't that help explain paragraph 5? Company and contractor desire to enter into this agreement in order to provide construction estimates by contractor. Doesn't that help explain even further that his job is to provide construction estimates? He's not out there like a hammer. He's not out there to collect checks. He's to sign up people, give them estimates, and sign them up to have DNS do the work.
Yes, Your Honor, which in the record showed overwhelmingly that he did all that work.
okay, and so then my next question is, on the compensation schedule, as we get into the list of, first off, the word compensation schedule, to me, there's a term of art in construction, a construction schedule. A compensation schedule sometimes can specify duties, sometimes cannot. And that's why I have such a hard time with this Exhibit A, because it just really doesn't seem to describe any specific duties. Is there anything other than paragraph 3, I suppose, under salary and pay, is there anything else on this exhibit that describes further what the duties are specifically of the contractor, of the salesperson?
Not that I see, Your Honor.
Okay, and then I get to Exhibit B, which again, it further confuses this, where it says 30%, 35%, and 40%. gives 3 options for the compensation schedule, which I think everyone agrees that 40% option is paid. And the only difference I can see between the 30% and the 40% is one says full company support program, and the other one says contractor conducts all aspects required. But what's the difference? What's your understanding of the full company support program? Is that?
I don't really know if I have an understanding of that, Your Honor. I think the contract was a bit ambiguous, it was a question for the jury to decide.
And then I look at the 35% section, and the 35% section doesn't mention either full company support or that the contractor does everything. It just lists the same items that have been listed under the 30% option.
But we do know in Exhibit A, not to cut you off, Your Honor, it does reference 40% is to be paid to my client. So it seems like that's what they elected was a 40%.
And then I see that the paragraph 5 of Exhibit A states that the balance of owed commissions is paid when the job is fully paid. The balance of owed commissions when the job is fully paid. I'm adding a word in there because again, it's kind of a broken sentence. Is it your understanding that once the job is paid, contractor is supposed to receive his money at that point?
That would be my understanding and the typical course of practice.
Okay, all right. So do you see these compensation schedules as anything other than time schedules?
That was what our argument was, is that this is how the segmenting the pay.
Thank you.
And I know I have maybe a minute or two extra. I would just like to address.
You got 2 minutes, Council, so just watch the clock.
So I just would like to address the issue of damages. The Levitt case, which is cited by the appellant, had to do with a general contractor who was terminated halfway through his contract, and he estimated he was entitled to get the surplus dirt from the project. He looked at the project and said there was about $1.5 million worth of dirt profit left in there. The court said that that was, too speculative. And notably, in the Levitt case, they reversed for just a new trial on damages, didn't throw out the liability finding. Here, in this case, the court, our job is to look at the record and see if there is anything that in the record that would support the jury's verdict. I asked the client, and we talked to him numerous times in the trial, and he confirms that labor, materials, everything all in was a $650 per square. What we heard counsel talk about was that there might have been some invoices out there to show the actual job costs. Accounting allows you to estimate. If you have a big batch of roof tar and you use half of it, you can estimate what those job costs are. That would have been great fodder for cross-examination for them to come in and actually walk them through. And I think it would be a much different record for the court if I said each file was $650, each project was $650 per square cost, and they had a whole bunch of ABC roofing invoices and showed it was far in excess of $650. That wasn't it. This was an admission by the party opponent, which again, they agree it was $650 was said. They just cast it as an aspirational target now. Our client, so you have a factual question. Was it an aspirational target or was it an actual statement of cost profits? I believe it was an actual statement of cost profits as the jury decided. And we met our burden of proof on the lost profits. I'll rely on my papers for the rest of my arguments. I thank the court for the time, and I ask that the court affirm respectfully. Thank you.
Council, as a prompt, I'm going to give you a couple extra minutes because I know we asked a lot of questions.
Sure.
Okay, thank you.
Counsel, do you agree with the legal assertion that an ambiguous contract, assuming it's ambiguous, creates a jury question as a meaning?
It could, Your Honor, if a legal determination is made that the contract is ambiguous. That is not something that was done. That would be a question of law that the court would have to do. The court would have to come in and say, we can't really figure out what was meant by these material terms. That's not what happened at the record below.
Do you think this contract is unambiguous?
I think the parties both understood what the contract intended.
I'm asking you, do you think the contract, would you advise a client
No,
to sign this contract?
I would not personally. Your Honor.
Would you tell any client this contract is unambiguous and won't create problems for you?
Your Honor, I don't know if I would go so far as to say that. I can definitely see how
It's very ambiguous, counsel.
I understand.
It's very ambiguous. You've got three smart people, we're okay. None of us can figure out what it means. It's extremely ambiguous.
Again, Judge, on the record below, though, we have testimony from the appellee saying that he understood what was meant and he understood what my client meant. as to what was required. That is testimony that we cited in brief. I brought it up here. If the parties are both in agreement, if we have testimony from the plaintiff saying, I knew what they meant, I knew what they wanted, their argument was, I just didn't agree with it. I didn't think that was what I should have to do.
But counsel, if you're saying that we think the meaning is clear because of what the parties said, rather than what the contract says, that seems to me to be an admission that it's ambiguous, but the evidence as to the meaning is, well, all the parties agree. That doesn't mean the contract itself is unambiguous. That's something you judge from the face of the document. That means whatever ambiguity was in the contract, we think all the parties agreed on the meaning, but that's precisely what the jury is to decide, did the parties agree on the meaning?
Correct, but again, the issue here, though, is that if you're looking at simply the testimony itself, if the testimony on both sides is agreeing, then how can the jury vary against what's in the record? It's not. Is there some small scintilla of evidence that would support this? Is the manifest way of the evidence that this is what the requirements were and were they met? On this record, the appellee testified as to what was required and testified that he did not meet those requirements. That is uncontroverted, pages 372, 379, and 826 to 829. And with that, Your Honor, I'm clearly out of time.
Before I let you go, I do have a couple extra questions.
Sure.
And I want to give you a chance to respond to the general line of questioning I was giving to your opponent. So getting to this page 2 of Exhibit A, and looking at this sentence that Judge Mize was questioning you about as well. The specific sentence there, since all tasks are weighted equally, those are the tasks of sign the agreement, turn to job number 1, build production number 2, and 3 collect. Since all tasks are weighted equally at 1/3 each, failure to perform any of these tasks may result in a deduction of applicable commission for the amount of 33% per item. Failure of who?
Excellent point, Your Honor. I would point the court back to the previous page, though, that starts out this whole exchange. If you're thinking of looking at this in terms of it being a continuation on Exhibit A, it says very specifically that the payment to the contractor will be made in accordance with the following breakdown, and then it sets forth the breakdown. We then proceed on to the next page, and it then states that here's how we're going to weigh these tasks in terms of a calculation of the percentages of the profit that you're collecting. And the failure to perform any of those tasks, that word failure to perform obviously implies that these are more than just a time frame that's going to, once this time frame is met.
But whose failure? What if the company fails to actually put the roof on? Does that count as a failure? Why would that not count as a failure based on the way this is worded?
I think it probably would, because, and they wouldn't realize the profit.
I would agree with you, counsel. On this, I think, unfortunately, this is where I'm going. Failure to collect. What if the company fails to collect? What if they do something to defraud an insurance company and collection cannot occur? That would be a failure. Would you not agree of this?
I would agree, but that would also trigger the beginning portion of this document, which is that the payment is due upon collection. There are draws that you can take.
And then that gets me probably to my final question,
yes,
which is the paragraph 5 on the first page of Exhibit A, which says the balance of owed commissions when the jobs were paid. And my question to you, based on that statement right there, why cannot this court look at this statement and say everything else is a time schedule? Once this job comes in and it gets fully paid, the contractor is entitled to their 40% of the profits.
Because
For more, when you answer that question, counsel also answered, why couldn't a jury do that with a very ambiguous contract?
Because
Answer my question first, and then you can answer.
yes, sir. Because I believe that the contract itself specifies that there are phases to this, and that is also what the testimony said. And to answer your question, Judge, I think that if the jury were to decide that, it was not presented to the jury as being an issue of ambiguity. Again, that was not something that was defined and put forward to the jury, and the instructions were on the verdict form.
Well, ambiguity, it's patent ambiguity. That's a question of law, and this court can determine once it reaches appeal whether there's an ambiguity or not. That's the challenge with, well, the lower court didn't do it. Yeah, sure, they didn't do it, but now it's on appeal. We can look at this de novo, and if there's patent ambiguities, latent ambiguities, we can't resolve those. But certainly, I think we all are telling you we see patent ambiguities. And then just, I guess, a quick follow-up to Judge Mize's question or his point. When I see a word like failure, on Exhibit A, page 2. Failure to meet mens rea implies some sort of intent, it implies some sort of an act on the part of a person. In essence, if you spilled a cup of water in someone's house, and then you go outside to grab a towel to wipe it up, and they lock you out with a deadbolt, have you failed to clean up that spill? You would say, no, Judge, I didn't fail to clean up. I was prohibited from cleaning up. Somebody locked the door. So my problem with this word failure, in addition to all the other issues, is this failure does not apply once if you lock the door and you lock your contractors out prior to collection, which seems to be the only thing that really kind of controls payment. That's not failure. That's prohibited from. So response to that?
Not according to case law in this state. Kelly v. Gills, for instance, one of the cases that we cited to Judge Orfinger, you referenced some of these cases that refer to terminable at will contracts. The mere breach in terms of there being a termination, if you want to call that a breach, it cannot be the basis for a good faith violation.
Yeah, but all those cases hold that if you earn something before the termination, you still get paid for that. So I think that goes to the heart of Judge Smith's question is, did he earn it before the termination, and these follow-up items didn't actually have to be performed in order for him to have earned it prior to the termination, right? That kind of begs, your response kind of begs the question.
Well, because, and that's actually my final point here, is that we have two things going on at the same time here. We have one argument that's been raised that is, we did everything that we need to do, award us money. The other argument is, we didn't do everything, but these people prevented us from doing it, so we should still get compensation. It needs to be one or the other, and the defect in this jury's verdict, one of many, is that they decided both. I'm way over my time.
No, they didn't decide both. They decided he earned the commissions. They didn't decide he completed those functions. The verdict form doesn't say did he complete those functions. It says did he earn the commission for those functions.
You are correct, Your Honor. I apologize. That is true. I guess I should say that they decided both the breach of contract and the breach of the good faith that we were dealing, and the arguments that were made in support were what I just stated.
All right, I will go. Thank you, counsel.
With that,
we held you much longer than you've argued for us.
Thank you, and I appreciate the court giving me the time.
Y'all ready to?
Yeah.
Okay, next case, 23-460, Joseph Martino and Marie Martino versus People's Trust Insurance Company. Is it Mr. Trevor?
Yes.
Okay, and so you may proceed with it. And sir, how much would you like to reserve for rebuttal?
7 minutes.
Okay, you may proceed, counsel. Thank you.
May it please the court, my name is David Charlotte. I represent the Martinos in this appeal. I'd like to start off by talking about some policy considerations first.
So I think we want policy considerations last.
Okay.
You didn't draw the panel that's interesting policy considerations.
I'll take it, counsel, if you want to proceed.
This very quickly. I think it's important to note that timing and the passage of time matters. Most of these opinions that we see in this area don't talk about it. But in this case, I think it's very important. Secondly, I think it's very important to talk about the circumstances that the insured suffers after a hurricane loss and the need for the insured to get assistance from the insurance company. When we look at those factors and apply them to the facts of this case, I think the court is compelled to reverse the summary judgment entered because numerous issues of material fact were adjudicated by the court improperly that should have been left for the jury.
Well, isn't it undisputed that your clients, the insurance company requested appraisal, and that your clients failed And apparently, they said they couldn't afford it, but the reality is they failed to participate in that mandatory alternative dispute resolution technique. I mean, is that not undisputed?
The appraisal request was March 30th, 2018, 8 months after the loss. That's acknowledged by the insurance company.
And what was your client's response to that?
Our client's response was that they had substantially made a number of repairs to the property. They had contracted with a public adjuster to do an appraisal. And at that point, the issue was really moot because the insurance company, they had not received the initial letter from the insurance company. They were calling the company, asking for the company to come out and fix the things.
I get the idea that the insurance company apparently, I think this is the case where they kept sending it to the wrong email address.
Correct.
But nonetheless, they were told about it on the phone, and apparently they communicated with counsel, or they communicated with the adjuster who gave that information. They ultimately got all the information, they just didn't get it in the direct form because the insurance company didn't quite seem to shoot the email. The bottom line, though, is the dispute here wasn't over coverage. The dispute was what's the amount of the loss. And,
Correct.
and so when the insurance company demands the appraisal, what did your clients do? They didn't participate in the appraisal.
Correct. They didn't.
And isn't that the basis upon which the judge said you didn't comply with the contract? And the insurance company has no further obligation to indemnify.
That's what the trial court said, but the interesting thing here is the suit was on the Drew contract, the new contract that was formed when the insurance company invoked the election to repair. The trial court then said, well, no, you breached the provision of the previous contract.
Counsel, there's nothing about a Drew contract. The Drew contract creates a contract for repairs to be conducted, but the repairs still have to exceed the amount of the deductible. And there's no case in the Drew context I'm aware of that says appraisals or alternative dispute resolution processes go away. They said, we think it's below the deductible. For anything we do end up after repairing, we're going to create a Drew contract. But since we don't think there's anything above the deductible, we're not going to pay. Your client sent a sworn notice of loss on March 8th saying, we do think that it's higher, right? The company received it on March 8th. March 30th, less than, about 3 weeks later, they say, all right, we have a disagreement about whether the amount of repairs exceeds the deductible. Let's go through the appraisal process. And it's not like your client said we need more time or something, just refused. They said absolutely not. They never, even up to the point of filing suit, complied with the appraisal process. And I'm not aware of any Drew case, any case involving a Drew contract that says the appraisal process from the original insurance contract goes away.
The Ainberg case says the cause of action recognized in Drew was a right to recover from an insurer for defective performance of a right to repair contract, a right which is outside the policy of insurance.
Yes, but the Drew contract only applies to damages and repairs above the deductible. To determine whether there are any damages above the deductible, you go through the appraisal process. I'm not aware of any case in the state of Florida, if there is one, please give me the site, that says if there's a Drew contract created and there's a dispute about whether the amount of repairs exceeds the deductible, the appraisal process goes away. Is there any case in the state of Florida that's ever held that?
Not to my knowledge.
So we'd be the first.
Well, we're not asking you to hold that. What we're suggesting here is that due to the passage of time and due to the fact that the initial notice that the insurance company sent by its own mistake was sent to the wrong email address, our clients never got notice of the estimate that was below the deductible. Our client testified that they incurred $4,800 just to replace the water that they had been.
So they didn't never get notice. They eventually got notice.
Eventually.
And upon getting notice, they provided a sworn notice of loss saying, we think the repairs exceeds deductible. Within 3 weeks, the insurance company said, okay, we've got a dispute, appraisal. Tell us your appraiser and we'll appoint ours and we'll get this going. And your client said, no, I will not appoint an appraiser, I will not comply with the appraisal process, correct?
In his deposition, my client testified that they had already spent approximately $20,000 to $25,000 during that time period fixing things.
Counsel, when I ask you a question, I want to answer. Did your client, or did he not, refuse to comply with the appraisal process?
They did not comply, correct? That's undisputed. But the reason they didn't comply was that it's a futile act. Because to comply with the appraisal process and to have the insurance company come in and say, we will make these rapid response repairs 8 months later that had already been in part done was something that didn't make any logical sense. My client testified.
That presupposes that the appraisal would have indicated that those repairs were necessary. Here, the basic dispute was not coverage, but what repairs are necessary. They say it's under the deductible, and we say it's over the deductible. And the policy has a specific provision for how to resolve that dispute. Now, if they had resolved it in your favor and said, yeah, the damages are, $50,000. I agree at that point, if your clients, because of their refusal or their erroneous estimate, had put off repairing, and you can't leave a big hole in your roof or whatever the problem was. If they had taken actions to repair it, different story. But we don't even get to that point, it seems to me, if we don't have a method of resolving what are the damages that the insurance company is obligated to pay. If they did it right, if the damages were less than the deductible, they would know you a penny.
The question in my mind is, was the insurance company's actions reasonable? Here, they send a letter to the wrong email address. An adjuster gets sent out, my client incurs $4,800, $200 less than the deductible, just in replacing the water. He's clearly got damages to his roof, and the deductible is a bit shy of $5,000. And yet, he hears nothing from the insurance company for months and months. The only thing they ask him to sign is a repair authorization, which he signs, which is for temporary emergency repairs. That authorization states that he is under an obligation to protect the property and to not let it get bad. He's sitting there with mold, he's sitting there with a roof that's leaking, he's sitting there with a bathroom he can't use, and so he has to incur his own money to fix these things.
I think what Judge Orfinger is saying is people disagree about what things are actually necessary, right? Insurance company might come in and say, hey, I think that mold was already there. I think it's caused by some other non-covered event, right? And the method of resolving whether those repairs were actually necessary, whether they happened before or after, was through this appraisal. And so had your client gone through the appraisal and the insurance company, found some repairs were necessary and he'd already completed them, that'd be a whole different story. But to this day, the mechanism that was intended to resolve whether those repairs were actually necessary still has not occurred because your client refused to go through with it.
That mechanism had it been employed in the beginning, I agree, would have been appropriate and proper. Due to the passage of time, because the insurance company sent the email to the wrong
The trend
address.
here does not change. You can imagine a lot of timelines, right? Like what if the hurricane had hit and a pipe broke and it's gushing water, right? There's thousands of gallons, okay? There's no way on earth any insurance company could possibly, go through a process as quick as he needs to fix that pipe. It's gushing hundreds of gallons of water, right? He may have to fix that immediately, that day, right? He may need to get a plumber team down there. He may need to run to Home Depot, whatever he's got to do. He still would say, okay, because I couldn't do this quick, because I had to do these repairs before we go through this process, I'm immune from the process. Nowhere in the contract does it say, hey, if you have to do anything so quickly that you can't get in touch with us, by the way, later on, you don't have to go through the appraisal.
Well, and I agree, but the statement that my client is making is not that he's immune from the process. What we're saying is that in doing something, taking your analogy like that, was he acting reasonably? And doesn't that present a jury question?
No.
That's our point.
Counsel, the contract didn't say be reasonable. It said do the appraisal.
Well, the contract also says that he's under the obligation to take action to not let the property deteriorate and to make repairs necessary. And that was also on the temporary
Yes.
work report.
And then to adjudicate whether those actions were appropriate and how much you get paid for them, go through an appraisal. I don't think anyone's saying that he shouldn't have, that there might not have been some actions he needed to take in the meantime. But how all that comes to a head and you decide what he gets paid for and what he doesn't is appraisal. And when the insurance company said appraisal, he said no.
Well, and the court found that the appraisal process was tied to the Drew contract. Our position is that it was separate from the Drew contract, and that from a timing standpoint, the insurance company had the right to wait and not even invoke the Drew contract because their position was that the loss was within the deductible. There was no reason to assert and invoke a Drew contract if their position was the loss doesn't meet the deductible.
And that's if they were right, then you would agree with me, wouldn't you, that there is no Drew contract? If the damages were $3,000, there's no need for a Drew contract.
No need.
Right.
Correct.
And
Absolutely.
if the damages are $50,000, then under this repair, then there would be a need for a Drew contract, unless your client had already done all the work and could make a credible argument that this had to be done promptly, and the insurance company messed around for 8 months or whatever, and I couldn't be without a roof.
Exactly.
But how does that obviate the rest of the contract? The contract, and specifically the rider that talks about the right to repair, both have appraisal processes in it.
Correct.
And it seems to me that this type of a dispute is exactly what the appraisal process is designed for. So I just don't understand the legal justification for not participating in the appraisal.
The legal justification is that the appraisal process was invoked months later after the work was performed.
Did you argue to the trial court that they had somehow waived the right to appraisal?
We argued that they waited too long to invoke the appraisal process.
Where's the law that puts a time limit on that?
And counsel, you are into your rebuttal, so if you want to reserve response on these and wait, or you can finish up your response.
Counsel,
I'm happy to respond.
Okay.
where's the law that puts a time limit on when they can invoke the appraisal process?
The Arguello versus PTIC case talks about the insurers complying to some extent with policy requirements, and that there are material fact issues as to the compliance and prejudice in the insurance company. We feel our case is most analogous to that.
Hold on, I believe that case involved somebody who waited a long time to do something, right? And the idea was, would the insurance company be prejudiced by how long they waited? Here, your client never did it, right? They never did it. To this day, they haven't gone through the appraisal, correct?
Correct.
Okay, so it's different than those cases.
The case is different from that standpoint, but it's similar in the sense that my client didn't take any affirmative position to prejudice the insurance company. The insurance company has never said, nor has the lower court evaluated, whether the refusal of my client to participate in the appraisal process prejudiced the insurer.
Counsel, all the cases dealing with prejudice talk about missing a deadline or waiting too long to do something. None of them talk about completely failure to participate in what is essentially an ADR process. To this day, he has not participated in that process. So I asked you once, and I asked you a question, you answered something other than my questions. I want to ask you a question, I want an answer. Is there a law or a case or something that puts a time limit on when an insurer can invoke an appraisal process?
Counsel, did you argue in the lower court that there was no prejudice to the insurance company?
Yes.
Okay, where in the transcript, where the record for that?
I'd have to pull it from the
Okay,
article.
well, you'll have a moment. I'll stop time. Thank you. Council Years.
May it please the court, good morning, Mark Tinker on behalf of People's Trust Insurance Company. I'd like to, just because you ended there, Judge Smith, I'd like to start with the issue of prejudice. The trial judge actually did address prejudice, and I believe the prejudice is inherent, and what has occurred here is that People's Trust has been deprived of the benefit of its bargain. We have, the cases that have looked at prejudice, and I think I'd like to contrast two of them that we've cited in our briefs that kind of spelled it out for the court. Gonzalez versus People's Trust was an issue where there was a dispute over whether an insured was going to sign a work authorization or not. And I'm sorry, fill out a sworn proof of loss or not. And the insured didn't provide an estimate. As it turns out, People's Trust hadn't provided their own estimate. They'd inspected the home, but they hadn't come up with a valuation either. There was a dispute over whether the insured therefore prejudiced People's Trust by not signing a sworn proof of loss. And the court said, well, that's a question of fact because it's disputed.
Isn't this more analogous to cases involved, saying like the pre-suit mediation process or pre-suit ADR process, right? If there's a mediation provision in a contract and somebody bypasses it and sues, on the other side moves to stay pending mediation, you don't say, well, we were prejudiced by bypassing the mediation. You say there's a condition precedent to the suit that you were required to fulfill. That was an ADR process called mediation, because this wasn't a situation where there was a delay. This was a situation where there was an alternative dispute resolution process that was mandated that was never complied with prior to filing suit.
I agree with you, and that's kind of where I was going. I was taking a roundabout way to get there, admittedly. But this is where you get to a situation where it's a yes or no issue. Did they sign or did they agree to go to appraisal or not? There's no evaluation that needs to take place, no weighing of anything. That is the entire process stops right there because they will not go to an appraisal. And that puts it, what the trial judge said when she was looking at it, she says, it doesn't make sense to look at it the way that Martinez counsel is, because she said, otherwise the right to repair and the discounts that are given because of that would be completely void, would be completely non-effective. So she's saying you got a discount to put this appraisal provision in there, the entire preferred contractor endorsement, and putting the appraisal that goes along with it. You got a discount to put that in there, and then you're just stopping the process and saying, we've given you our estimate, but we will not, we created a dispute over what needs to be repaired, but we're not going to allow you to go figure out, to resolve that dispute. We're not going to go to appraisal. So they stopped the entire process and deprived People's Trust of the benefit of their bargain at that point. That's where the prejudice.
Isn't there a presumption where there's a non-compliance with the material term of the contract? Isn't there a presumption of prejudice that they didn't have to rebut?
Yes, Your Honor. And I believe that's Johnson versus Allstate. I think it's the Supreme Court case.
Counsel, saying they just waited a few months. So they just waited 3 months and then said, okay, we'll go to the appraisal process. And your client said, well, it's too late. And then they sued. Then would it be an issue of prejudice because there was some time delay, but ultimately they were willing to comply with the condition precedent?
If the insured waited a few months and then.
Yeah, so I think out of this, the appraisal process said they had 20 days to appoint an appraiser. And I think that 20 days went by and your client gave them an extension. I think it was 15 or 25 days, said, no, seriously, appoint the appraiser. And they said no. What if they just waited another 30 days and said, I changed my mind, I'll do the appraisal, right? And your client said, too late, right? You had your chance. Then would it be an issue of prejudice, the fact that there was some time, but they ultimately complied with the condition precedent, as opposed to here where there was just a refusal to comply with the condition precedent before ever filing suit?
I believe they could attempt to rebut the prejudice by doing that, by saying, yes, we were late, but we can rebut the prejudice by showing that, perhaps the construction costs hadn't changed in the interim. If they wait 5 years, the cost to fix the house now is going to be drastically different than it was 5 years ago because of costs and because the roof has been open perhaps for 5 years or whatever it might be. Then, there would be a presumption of prejudice there, and they could rebut it by saying, no, it really wouldn't be any different. And, even though we were late, we rebut the presumption. But the presumption would still exist. And in this case, obviously, I think that's a hypothetical exercise because we know we've gotten all the way to this point. The trial judge even commented after granting the summary judgment. She said, I'm surprised nobody asked me to compel an appraisal. Sure, you didn't compel that.
Did you have a follow-up? Okay, go ahead.
Well, I was going to say, so in those instances, it's a delay. And so the issue the case law speaks to is, did the delay prejudice the insurer, right? Here, it's not an issue of delay. You were deprived of the process completely.
Correct.
right? Do you think that the condition precedent of filing suit is the better analogy?
I agree with that. I think it's a good analogy, yes. And, I don't think there's a question as far as that it's been an absolute deprivation, and council conceded that here today even, but we've gone all the way through the process. When presented with the suits, they never moved to compel an appraisal, never attempted to comply, instead filed a counterclaim for monetary damages, moved to dismiss these suits, opposed the summary judgment by saying that we could not compel appraisal, there was no valid right to it, so that, all the way through till standing here today, we still are depriving people's trust of the benefit of this bargain. The other issue, if I could move along, is the only other issue that has been argued today is this question of notice. And there are, the initial notice, there are three issues with that. Actually, I have three things to address with that. The first is, I think that the court has kind of latched onto it a little bit, is I think it's kind of a red herring argument at this point, because we're talking about initial notice of the, here's people's trust initial estimate, and then the invoking the right to repair. Well, we've gotten past that now. We've gotten to the point where the trial judge said, well, we know you did get the notice eventually. We know that you know about it. You got your own appraisal. You have your own estimate of damages. You supplied it. You've admitted that now there is a dispute. You guys disagree as to what the repairs need to be. And now you're refusing to go to appraisal. So there are different duties. The duty to provide a sworn proof of loss, they complied with. The duty to go to appraisal, they have not. So we're talking about different duties. And Castro versus People's Trust, which has been relied on heavily in our briefs, actually looked at that exact thing, where the insured in that case provided a sworn proof of loss, actually went to appraisal. The case went into a lawsuit, and there was a motion to compel appraisal, and then the insured went to appraisal, and after appraisal, refused to sign the work authorization. So that was another similar situation where we just cut off the process. Now we have the appraisal, we know what needs to be fixed, but the insured will not sign the authorization to allow the contractor to go in and actually do it. And the court found that to be something that voids the contract, that voids coverage, because it's not compliance with the condition.
Council, there's been a lot of.
There was a formation of a true contract. Here, we never got to that point, if I understand it correctly, because the refusal to comply with the appraisal, right?
Well, I believe there's
Isn't that significantly different than the case we were just talking about?
I think there is a Drew contract subject to the terms of the policy, and that's what the case law spells out. The Drew contract isn't its own animal that means the parties have no rights, there's nothing guiding what the rights or obligations are. It's a Drew contract to repair the home that's formed as soon as People's Trust makes its election to repair, which it did timely here. The policy says you have to do that within 30 days of inspection. People's Trust did that. So they've made their election to repair. We have a Drew contract subject to the terms of the policy. The policy says, it's below deductible, so there are no repairs until we agree to something that's, either we agree to something above deductible or an appraisal panel tells us it's above deductible. If that happens, then we'll repair actually send out our preferred contractor and repair the property. So there is a Drew contract, but it's subject to the terms of the policy.
And it's for the amount above the deductible, correct?
Correct.
Council Lancy, they put emphasis on the sending the letter to the wrong email address in the notice. And it does seem like that was a screw up. I'm sure your client didn't, I'm sure they wish they would have sent it to the right email address, right?
Well, that's one of the three things that I was going to mention about that, because when I'm looking at this record, there's the affidavit of the People's Trust corporate rep, Ariel Nolan Peters. She says, here's the letter that we sent. It's the initial coverage letter. It doesn't show that it was sent email. It shows that it was mailed to them at the mailing address. Some other letters that are in the record subsequently do show that they were emailed and mailed. This one only shows that it was mailed. The policy says that a mailing sent to.
That proves it was actually mailed?
That's not in the record. What is in the record to dispute it is an affidavit from Mr. Martino, from Joseph Martino. And he says, neither my wife nor I received it. So if we're talking about, we're here at a summary judgment, he can file an affidavit saying, I didn't receive it. The saying my wife didn't receive it wouldn't even be admissible evidence. So we have an evidence so far saying, here's the letter that was sent from Ariel Nolan Peters. It shows it was sent to the address. The policy says anything sent to that address shall be deemed effective. I believe 5 days after mailing, it shall be deemed received. So we have the presumption that it was received. Mr. Martino, Joseph Martino said.
You have to have some, the letter says sent by mail, but you got to, I don't think the record show it was actually mailed, does the presumption arise? Presumption arises from the proof of mailing, you don't have proof of mailing.
There's no proof of mailing outside of the affidavit saying they were notified in writing, here's the letter attached.
Does it say we mailed it, here's the tracking number?
It's not.
So there's no proof of mailing.
No.
My point is, that seems like a screw up to me. And if they had complied with the appraisal process and then said, hey, our ability to assess the damages and to perform the appraisal, and also we had to do all these other damages we had to do all these other repairs in the meantime because of your screw up. If they had performed the appraisal and then blamed you all for that, would they have a much stronger case against you?
They did that except for the appraisal, Your Honor.
That's what I'm saying. Have they complied with the appraisal and then said, by the way, there's all these damages we had to do in the meantime because we had a duty to protect the property, and also you weren't responding to us? Seems to me that would be a much stronger case. It seems to me it hinges on the refusal to do the appraisal, kind of deprive them of the ability to make that argument.
It does hinge on the appraisal, and why I say they did that is, of course, we had the initial delay where they're saying they didn't receive the letter. Then they did get notice. They agreed that they had notice because they went out and hired their own appraiser and they got an appraisal done. They submitted their estimate and they submitted a sworn proof of loss. And in that proof of loss, they include everything that council talked about and everything that they complained about with the delay. They include the water stopper. They having to hire Culligan Water to bring them water. That was included in the sworn proof. A hotel stay that they claimed they incurred. They put all of those in there saying, here's our loss. And so now we have a dispute. People's Trust wants to go get that appraised to resolve the dispute, and they refuse. So they had done all of that. They put everything in.
Counsel, I see mention in the record of a phone call, some sort of phone contact. Was there any refusal? Is there any record evidence of People's Trust refusing to receive a phone call, respond to a phone call? In essence, there's discussion of, what's the wrong email address? Was the letter sent? Was the letter not sent? Well, clearly was at some point received because they obviously hired a public adjuster to go out there. Is there any evidence that if the Martinos would have just picked up the phone and called their insurance company and said 30 days after they filed it, what's the status of my claim, that the insurance company was giving false information, refusing to provide information? Are you aware of any? I'm probably going to ask your opposing. And I do want you to respond. I know opposing counsel made a point. He said, your appraisal request came late. It came 8 months after the date of loss, and so therefore we should really be looking at. What's your response to that?
The appraisal paragraph, the appraisal provision in the policy says that once a dispute arises, then either party may demand appraisal. And the Martinos provided their sworn proof of loss. It was transmitted to People's Trust on March 8th of 2018. On March 30th, People's Trust demanded appraisal. So it was just 3 weeks approximately later. So it was not too late. There was no time frame in the policy, but if we're speaking about reasonable times, it was 3 weeks after they finally supplied the materials that created the dispute that needed to be resolved by appraisal. Before that, there was nothing to appraise. There was no dispute. People's Trust had provided its estimate. There was nothing conflicting.
Thank you.
Unless the court has any other questions, thank you for your time and give the rest of my time.
Okay, thank you, counsel.
To respond as it relates to the prejudice argument, in record site 481, as part of our response to summary judgment, raised the Kramer case and talked about the lack of prejudice, or the issue of prejudice being a fact question. And we argued that it needed to be evaluated, and it was a jury question that would prohibit the court from entering summary judgment. The prejudice
Just asserting that it's a fact question doesn't necessarily make it so. There has to be some material fact in dispute. So what we know for sure is they demanded appraisal. Your client didn't comply. Under the case law, at least as I understand it, that creates a presumption of prejudice. Now, if your client had come in with some evidence to demonstrate, to try to rebut that presumption, maybe we'd have something that we needed to talk about. but how is there a fact question if your client doesn't argue anything to demonstrate, to try to rebut that presumption of prejudice?
Well, the Godfrey case talks about the presumption of prejudice not being something that is the burden of the insured when the insured partially complies with his duties under the policy. And so in this case, our insured did everything that he was aware of he was supposed to do. Having not received the letter, he didn't receive any of those instructions. The only thing he did not do was months later, when the request was made for the appraisal, his position was, I got an appraisal from the insurance company, I went and hired a public adjuster. He didn't really understand appraisal, the difference between the appraisal process and getting an appraisal, but the response was, I'm done with appraisals. So in that case, we feel that the burden is on the insurance company to demonstrate.
Your position essentially is that the presumption of prejudice did not arise, and so you had no duty to rebut it.
Correct. Correct. And the court didn't address in the summary judgment order. So, the other question about and I'm sorry, Judge Smith, you wanted me to comment, just lost my train of thought.
You answered my question.
Oh, okay. So our position here is that, as I said, this case is very similar to the Arguello case, because our insured complied to some extent with the policy requirements. The policy language itself requires the insurance company to prove that it was prejudice. And that's where the difference between the presumption of prejudice and the obligation of the insurance company to prove prejudice differs. And the material fact issues that were present in Arguello are similar to the issues in this case as to compliance and prejudice.
Let me just ask a question. Did you just say that the policy here requires the insurance company to prove prejudice?
The language says, it says we have no duty to provide coverage under this policy if the failure to comply with the following duties is prejudicial to us. It's the same language that's in the Arguello case, section C, duties after loss. Thank you. And so we would ask this court to reverse the judgment.
Thank you, counsel. Our next case, case 23-1510, Bryant Lane and Jalen Hunter. Counsel, you may proceed.
Good morning, Your Honors. Philip Arroyo on behalf of the appellant in this case, Mr. Brian Cohen. It is the appellant's position, Your Honors, that the lower court in this case erred, and that during the injunction hearing held, insufficient evidence was presented to warrant or justify the entry of the injunction. As we all know, a person commits the act of stalking by willfully, maliciously, and repeatedly following, harassing, or cyber stalking the person. Now, the crux of our argument on the appellant's side is specifically to the harassment problem. And we know that harassment is defined as engaging in a course of conduct directed at a specific person, which, number one, causes substantial emotional distress to that person, and number two, serves no legitimate purpose. It is the appellant's position, Your Honors, that the petitioner's attempt to reach the injunction is flawed in that it does not comply with the two subprongs of the harassment definition. Specifically, there was never any substantial emotional distress displayed by the petitioner.
Let me ask you this, counsel. Is it your position that in a stalking injunction setting, that every single act supportive of a stalking injunction, when we're looking at course of conduct, that every action must have the intent and the effect of substantial emotional duress upon the victim? Or is it the entire course of conduct that we look at? What is your position based on your reading of the statute?
Our belief is that it's something that the court can consider. However,
Well, I mean, from a statutory perspective, I mean, I think this was a big point that I drew from your arguments, on appeal at least, that there's this idea that the lower court needed to make this finding with so if somebody follows you with a car one day, they send you an email another day, they show up at your place of employment another day, that each act has to stand on its own and cause substantial emotional duress, and I apologize, I know I'm misstating the standard, and has to have that malicious intent that's required by the statute. Or do we look at in a stalking setting, and I know this is very specific to a stalking setting, because if we were just talking about repeat violence, you can't have repeat violence without intent. You can't accidentally bump into somebody and say, hey, that's the second time you bumped into me, that's repeat violence. No, it's not. It takes, each one of them has to be an intentional act. But the stalking injunction, do you view that every piece of the course of conduct, and again, I just gave you some hypotheticals, there, some of which intersect in your case, I don't, but following somebody in a car, sending them an email one day, showing up at their employment the next day, do we as a court, and I'm talking we trial judge, does the trial judge have to make a finding on each individual act as complying with the mens rea for both the person committing the act as well as the substantial emotional effect on the victim?
That's a very good question, Judge. Our answer would be yes.
So my question would be, tell me in the statute where you draw that from. Let's look at the actual language of the statute and see. Tell me how you make that argument. And if you have any cases that support that each individual act.
The statute states that each act of alleged stalking should be.
Which section is that, counsel? Give us a section.
It's
I'm going to give you a couple of extra minutes, Mr. Turner. I realize I didn't get started with that. My apologies.
I cannot find the exact subsection, Your Honor, but.
I'm looking at the definition of harass, and this is 784.0481 and sub 1 sub A. And it says harass means to engage in a course of conduct directed at a specific person which causes substantial emotional distress to that person in a certain legitimate purpose. So that seems to be telling me that it's the overall course of conduct that's got to cause substantial emotional distress rather than any particular incident. Because unless I'm missing something, that's what the statute says, course of conduct, not each event.
Correct. However, substantial competent evidence must be presented at the trial level on each and every one of those acts.
Correct, that they occurred.
Correct.
Okay, but the emotional distress, unless you point me to some other part of the statute, I'm not an expert on stalking. It's not a rhetorical question. If I'm wrong, please tell me. Unless, yes, you need competent substantial evidence as to each event in the course of conduct, but the emotional distress can come from the overall course of conduct rather than each specific incident. At least that's what harass means, to engage in a course of conduct.
Well,
which causes substantial emotional distress.
Yes, the appellant's position, Your Honor, is that there was a course of conduct. There were various alleged incidents. The appellant's crux of her argument is that none of them rose to the level of stalking because a reasonable person would not suffer substantial emotional distress.
So that none of them does a lot of work in that sense, right? Because none of them implies that each of them would have to, or at least one, right? And what I'm saying is, this goes to Judge Smith's question, that does not seem to have any support in the language of the statute. The statute says the course of conduct must cause substantial emotional distress. So that would tell me, unless I'm missing something, if there's some other part of the statute pointed out, that even if none of them would cause substantial emotional distress, if collectively they would, that can support an injunction.
Our position would be no. And we have some case law that we've cited, all three cases from the 50s.
Yeah, tell me the cases, counsel, I want to know specifically
When
which
you
ones.
look at, first of all, we have Slack v. King. And all of this was a domestic violence stalking case. The court concluding that nothing in the record demonstrated any basis for finding that a reasonable person would suffer substantial emotional distress. But it's important in that case.
Yeah, but did they say each individual act must meet the definition, must cause substantial emotional distress standing on its own?
It does not, Your Honor. However, what's very glaring in that case, and I think that may be applicable to our facts in this case, is that in this case, there was actually a situation where Kling testified that Slack left a voice message stating that if he didn't stay away from his wife, he was going to make an arrangement, which could be interpreted as somewhat violent. And notwithstanding that, the court ruled that that still wasn't enough to put somebody.
Counsel, that doesn't speak to that. I think you're picking up on a trend that we're interested in this antecedent legal issue, right? I don't think the 6th DCA has any prior cases on the stalking statute, which would be our first one that I'm aware of. We're not bound by any of the DCAs. We want to correctly interpret the statute. Correct. Unless there's a Florida Supreme Court case that tells us what to do, we want to look at the statutory language and get it right. So I'm looking at the language, and it says to engage in a course of conduct directed at a specific person, which causes substantial emotional distress. So when Judge Smith brought that up, instead of answering that question, you said, well, look at this other case where there was egregious conduct they didn't find to be sufficient. I want you to answer the questions. Is there a statutory language that says it has to be each individual event? And if not, is there a case that says that any individual event has to cause great emotional distress? Answer that question, not a different question.
The answer is no, not to my knowledge.
So there's no case that's ever said that?
Not to my knowledge.
Okay, so we'd be the first one?
That's my understanding under the 6th DCA.
Okay. No, but is there any of the DCA that has ever said that?
Not to my knowledge, Your Honor.
Okay, so there's no DCA that's ever said it's individual event cause emotional distress?
Well, other than the requirement that each incident should be.
Have occurred.
Substantial, competent evidence.
Correct, that they occurred.
Correct.
Correct. But there's no DCA in the state, no appellate court or Supreme Court of DCA that has held that any individual event must cause substantial emotional distress. So we would be the first to make that holding if we made it.
That is correct.
Okay, so since you're asking us to break new ground and make a holding no other court has ever made before, and there's a statutory framework we're in, we got to go language of statute. Which language of the, what language in the statute do you point to ask us to make that brand new holding that no court in the history of the state has ever made before?
Well, Judge, when we look at the statute, the central element of our argument is that there was no maliciousness in any of these incidents. And that's number one. Number two, there was no harassment. And when we look at the case law that we, again, it's not bound with the 6th DCA, but we're using it as guiding purposes for the court, we see that this is.
But counsel, before we decide whether it's harassment, we have to know what are we looking to this, what are we looking at to decide whether it has harassment? Are we looking at a specific event or each event separately to see whether any or all of them individually constitute harassment? Or are we looking at a course of conduct? All right, so let's focus on that antecedent issue. I asked you which one, and you said individual events. You said an individual event on its own, at least one or two, has to individually constitute harassment or cause substantial emotional distress. You admitted, I think that you had made the admission because it's true, no court in Florida has ever held that. Okay, so before you get into telling me what harassment, whether or not it constitutes harassment, tell me what you're talking about. If you want me to look at the individual events rather than the course of conduct, tell me where in the statute it says to look to individual events. If you want to abandon that argument, go to course of conduct, you can, but I want to be clear about what we're talking about.
I think there was a misstatement on our side in terms of substantial competent evidence for each and every incident. We do not deny that there was a course of conduct of contacts between the appellant and the appellee. Our argument is based on the fact that there was no maliciousness according to the statute and harassment.
Okay, so are you now saying it is course of conduct, that to look at the whole course of conduct,
Yes,
to decide
yes.
whether that constitutes harassment?
Correct.
Okay,
We
so,
can look at the course of conduct.
Okay.
Of course.
so any individual event doesn't have to constitute harassment if together they do. In other words, even if one event would
Correct.
cause substantial emotional distress, if together multiple events could, that can constitute harassment and serve as a basis for injunction.
Correct, Judge. And it's our position that all the events and the course of conduct doesn't rise to the level of causing reasonable, and a reasonable person in Florida, substantial emotional distress. One of the cases that Appellee mentions is a federal case, Burroughs, which takes a look at the constitutionality of the stalking statute in Florida. And it's very clear there, in that case, the court resolved that it's not easy in Florida for someone to suffer substantial emotional distress, and that idle threats, such as in the case that I cited, are not enough to rise to the level of substantial emotional distress. Now, in the essence of time, I would like to just address the three incidents that the lower court relied on in finding that the injunction proceeded. The first incident where was the appellant arrived at a bar, and it's noteworthy to mention that he arrived before the appellee was there. He's at the bar.
Did he know
Well,
she worked there?
wait, counsel,
Yes.
before we get to the bar, don't we have to start a little bit before that?
Yes.
We have to start on April 28th.
Correct, yes.
And on April 28th, what I see in the record is stalking always has to have a starting point. There's got to be the starting point where you have some sort of an expression to a person, I don't want you around me. I don't want you, I suppose there are pretty extreme situations where you just go right into the threats. But typically in a situation like this where there's been a dating relationship, there's that initial expression of, I don't want you here. And I think we definitely have to start there. We can't just jump into the second incident. Because when we look at the course of conduct, we have to make sure that we've at least got an expression from the petitioner that they don't want this anymore. And on April 28th, the record reflects that your client shows up at midnight, approximately, at the petitioner's residence, attempts to buzz in at midnight, uninvited. She does not even answer the buzzer, and instead texts him multiple texts, which I'll put some of them out here, just so that we start with this before we start with the first incident. First text to him, bro, are you really doing this right now? 4 question marks. Next text that she writes to him, you're tripping like you're doing a lot that's actually insane, how you hold up on me, okay? Next text from her, no, like you literally don't know boundaries. I'm actually PISSED, ASF, you tried to come here, like you are crazy. Next text, all caps, we are not talking. Next text, and I suppose this must be some sort of a name that goes by, dead ASS, leave me alone. Was that a clear line in the sand of him, of Ms. Turner expressing, I don't want any further contact?
Yes.
Okay, so I think it's important you start with that.
Yes.
And then I'm gonna release the reins to you, although you may jump in and ask me about the specific incidents, but let's go to what you're calling the first incident. But I think it's very important
Yes.
that there has to first be an expression by a petitioner saying, I don't want any more contact. But go ahead, Councilor.
Yes, and my apologies, I was just
That's
trying to
fine.
save time in terms of the specific incidents that the report found that there was active stalking. But yes, you are correct, Judge. The first incident was April 28th. He arrived at her apartment, buzzed downstairs. There was literally no verbal communication. From the record, we can see that the interaction lasted, if you can call it an interaction, 2 minutes, less than 2 minutes. He leaves after an exchange of texts. The lower court found that that didn't rise to the level of stalking. The second incident after that was 4 days later, where the appellant sent Appellee flowers. Appellee, according to the record during the hearing, testifying that she thanked him, said it was a nice gesture. However, she asked him to stop contacting him. The lower tribunal found that that didn't rise to the level of stalking.
But it showed two requests to cut off contact, right?
Correct. 2 requests to cut off contact. The lower tribunal found that those 2 incidents didn't rise to the level of stalking. That same evening is the bar incident.
Okay, but before we get to the bars,
Yes.
let's talk about this correspondence by text message. So your client, once again, sends these flowers after she says, no more talking, stop this, which we all agree was a stop this message. I would agree. And then on May 2nd, she sends him text messages thanking him for the flowers, which I can't necessarily fault her for that. But then she makes statements to the effect of, you still aren't listening to me. And she says, once again, as Judge Mize pointed out, I'm done. But what concerns me is what your client said. You at work, question mark? And then you're proceeding with your next incident, which occurs at her place of employment, where he just shows up, a place that he's never gone to before. He just shows up there, and we're supposed to conclude that's accidental, coincidental, even though just that day he had texted her, "Are you at work?" This, according to your position, is it's a total coincidence. Orlando's a big place, but my goodness, it's just an accident. He just happened to show up at work while she was at work.
No, Judge. We acknowledge that he did arrive to the bar. My understanding of the record is that she never answered as to specific time she
But did he arrive at the bar because she
He
was
did.
there?
Well,
Because she was there.
there's nothing in the record that indicates that, Judge. We have no substantial competent evidence or testimony from either side as to whether.
If somebody comes in here with a 99.999% accuracy, are we supposed to assume that because there's 0.001% chance that that action may not be accurate, that that's a false statement?
It is undisputed he knew she worked there, right?
Correct.
Okay, so he went to work, he knew she worked.
Correct.
He didn't know she was working at that moment.
Correct.
And he stayed there until she showed up.
Yes, we can agree to that.
How is that not following her? How can we not, looking at the facts in the light most favorable, looking at the substantial competent evidence standard, how is that not evidence of one act of following? That he shows up at her employment for the first time ever, after asking her, "Are you at work?" And he stays there, waits for her, and then has contact.
We're not arguing that it's coincidental. We are arguing, actually, we believe that this actually strengthens our argument, the fact that he had never been there before. Because had he been there before, he would know the exact time she would be in.
But he knew she
worked
worked
there, of course. But he didn't know the exact time she would be working.
What does that matter?
She even mentioned that she worked the night.
The fact that he's willing to go there and just hang out until she comes in, that seems to make it worse to me, not better.
Well, Judge,
He went there not knowing if he'd have to wait 10 minutes or 10
but
hours.
the issue is sitting at a bar, asking for a beer, does that cause substantial emotional distress? It does not.
But
It
counsel,
doesn't. Well, counsel, that's what we talked about
Correct.
here initially was, are we looking at a course of conduct? Or are we looking at individual actions, each of which must support? And I think we all came to the agreement based on the language of the statute and no controlling Supreme Court case law. We have to look at the course of conduct. We do. So
the question is not whether showing up at her work would constitute harassment. The question is showing up at her work after she's repeatedly said, "I don't want to talk to you anymore, leave me alone." She said it in writing multiple times, "Stop, I'm done, you're not getting the message." And then he shows up to her work.
And we have case law in our great state, the Ravage case, which indicates, in that case, it resolved that even when somebody asks, in this case, the appellant not to contact them anymore, that alone is not enough to find an act of stalking.
what is a
There's
single incident of somebody showing up afterward? Is that what you're talking about?
Correct, in regards to Ravage.
Well, we're not even on to the multiple additional instances. I count 3. But I will say, if you're into your rebuttal time.
Yes. We reserve the rest of
Okay.
our rebuttal.
And then we'll let you know.
Thank you.
Ms. Turner.
Can you please the court? My name is Jayla Turner, I'm here on behalf of myself. Your Honors, you guys asked if there was a case or anywhere in the statute that spoke to whether there had to be, each incident had to amount to substantial emotional distress, or if it was based on the course of conduct. And there is a case that is Leach v. Kersey. It was cited by the first BCA, and in that case, they stated that substantial emotional distress is an objective standard determined by considering the totality of the circumstances. And when it came to the court finding that the appellant showing up to my place of work to be an act of harassment, they were looking at the fact that just 4 days earlier, he showed up to my apartment and tried to buzz in after me telling him I didn't want him there. And that same day, just hours before showing up to my job, that he sent flowers. I did respond to him sending me flowers, but again, I expressed that I didn't want any contact. And then further showing up to my job, and as you guys referenced, in the exhibits, there was a text where he asked if I was at work. In addition, the court, in denying the respondent's motion for rehearing, the court concluded that the appellant showing up to the appellee's place of work to be an intentional act because the appellant did not provide testimony indicating he was indicating that he had gone to my place of work previously. Also, Your Honor, the appellant cash apping the appellee, that was found to be an act of harassment because it was undisputed that I had unequivocally stated that I did not want any contact with the appellant. And he testified to saying that a relationship coach advised him to reach out to me in a way where I did not block him. So he cashed out me the first day, August 10th, with the word Turks, and August 15th, again saying that you just really hurt me, that's not okay. And the court found that that was an act of harassment because I unequivocally stated that I did not want any contact with him. Furthermore, in the appellant's brief, they argued that because there was not anything threatening in the messages, that does not amount to harassment. However, the word threatening does not appear anywhere in the statute. There's a case, Con v. Dutchman, 282 SO3D 965 first BCA, which provides an explanation of what malicious means, defining it as behavior that goes beyond intent to cause injury to include behavior that is without just cause or excuse, concluding that the plain meaning of the statutory term maliciously is legal malice, wrongfully, intentionally, without legal justification. Here there is no just cause or legal justification as to why the appellant continuously reached out to me after me unequivocally stating I did not want any contact with him any further. In the appellant's brief, he also goes into the fact that there was a period of 40 days where the appellant did not contact me. In Florida Statute 784.048, Section B, course of conduct means a pattern of conduct composed of a series of acts over a period of time, however short, which evidences a continuity of purpose. There is no case that defines a specific period of time that has to go on for there to be a continuity of purpose. In the case Hutch v. Mars, a case cited by the 3rd BCA, one of the instances the court found to be an act of stalking took place over a year, an entire year after the initial contact with the petitioner. When the petitioner moved to Florida, that's when the respondent had followed her to Florida a year later and showed up at her place of work and at her home dressed as a delivery driver. Just like in Hutch, where the court still found there was sufficient evidence to affirm a petition, as should here, there should be a finding that even though there was a period of 40 days where the respondent did not contact the petitioner, it does not negate the fact that instances of following, harassing, or cyber stalking occurred. In addition, overall, the Florida statute for stalking requires that there be 2 separate acts or more of following, harassment, or cyber stalking. And here, there has been evidence that has shown that there were more than 2 instances of stalking or following or harassment and cyber stalking that occurred in this case. And if your honors have no further questions.
Thank you.
Your Honor, the appellant would ask that this court reverse the lower court's judgment granting injunction to affirm the lower court's decision would ultimately cause a slippery slope and chilling effect on people who legitimate, well, not legitimate means, but have a legitimate purpose of trying to salvage a relationship. And we believe that that could be a slippery slope. We can agree after looking at the record that most of, if not all, of the text communications, the verbal communications were respectful. Were not
Isn't that what that kind of what harassment is, when somebody says, I don't want to salvage this? The other person has to respect that. Like, you could say that for anything. You could say, well, hey, she kept telling me I wanted to salvage it. I wanted to salvage it. I thought I could convince her. Right? And the whole point of this is to say, as a matter of law, you don't get to do that.
Well, Judge.
I mean, there could be 100 times this incident happened, and you could say, yeah, but I thought I could salvage it. There was a legitimate purpose. I wanted to salvage the relationship. I wanted to change your mind, right? That could justify this going on forever, could it not?
It could. However, Ravitch is very clear, Your Honor. Case law in our great state that states that even continued attempts to establish contact where there is no maliciousness, there is no substantial emotional distress, does not rise to the level of stalking. And our chief case in our brief was Lazarenko, which I believe is pretty close to being on point. This was a case where the appellant, again, through multiple attempts, tried to establish contact to salvage the relationship. And the court found that, in layman terms, sappy love text messages or attempts to salvage a relationship did not rise to the level of stalking.
Well,
Even
counsel,
within the
let
record.
me just pause you there, because this isn't just about sappy love text messages. I would agree if that's all that we had, it would be a much tougher case, but we didn't even get into the last few incidents here. We've got the incident where on June 11th, the respondent, once again, shows up at a nightclub. And we're supposed to conclude coincidentally and by happenstance, just happens to show up at a nightclub. This is after we all can agree, he has clearly been told, no, stay away, I don't want this, I don't want to have any communication with you. He knows that. Rather than giving the petitioner her space, he approaches her, he grabs her by the arm, he separates her from a friend in order to grab her by the arm. And you would say that is normal sappy text message type stuff, or now have we crossed the line?
Well, we would say that the lower tribunal ruled in that specific case that there was no active stalking.
This gets to my challenge with the way you framed your appeal, and maybe even with the way the lower court handled this, where the lower court was attempting to have to find the substantial emotional distress element for every incident that occurred. And I believe we're all concluding that that's not what the statute requires. The statute requires a course of conduct. Furthermore, the tipsy coachman, we can take a fresh set of eyes and look at this record. And someone approaching a person in a club setting that has been told, don't contact me, and reaches up, separates their hand from their friend, grabs onto their arm, that's something. That's some sort of an act, a course of conduct, whether it's following, whether it's battery, whether it's whatever it may be. That's a strike. And then after that occurs, then we get to your recitation of events of what occurred several minutes later, because the petitioner says she then has to walk, her friends separate her again from the respondent. They take a 3-minute walk to the parking garage. Now, at the parking garage, her testimony is that he, again, suddenly just happens to show up at the elevator to go up the elevator to get to the car. He hops on the elevator. If they don't hop on the elevator, I think there's nothing wrong with that. I don't think anybody here would say we've got an issue. He stays on the elevator. He waits for the elevator doors to open again and steps out and begins to try again to engage with the petitioner. Are you saying that's not an act of harassment?
Judge, the record of that specific incident establishes that they were both at the same parking garage. This specific establishment, the club, has a parking garage right next to it. We would argue that it was coincidental that both of them were parked in that parking garage, that my client had to be at that elevator to get to his car.
But did he have to stay on the elevator? Did he have to stay on the
It's my
elevator?
understanding from the record that he did not go on the elevator with her. There was a friend with her that told her, get away, she's drunk, and
Right.
left.
She's waiting to get on the elevator.
Correct.
He stays on the elevator. He pretends like he's going somewhere, lets the doors close, and then voila, lets the doors open on the same floor. Don't we have harassment at this point? Don't we have an act towards stalking that he's clearly not getting the message, he's not getting away from her, he's refusing to separate himself from her? You think is that normal behavior?
Well, that could be an objective person that can look at it and bring.
Objectively, is that normal behavior? It absolutely is an objective standard, but objectively, is that normal?
And they can raise their own conclusions in regards to that, but the question here is, was it malicious? And was it?
What does malicious mean?
Substantial emotional distress. Malicious is defined, actually, one of the cases that I believe actually presented is the Khan case. Malicious behavior goes beyond intent to cause injury to include behavior that is without just cause or excuse. There was no intent to cause any type of injury. There was a legitimate purpose for Mr.
Is that definition of the statute?
No, this is the case law in terms of conduct.
Does the statute define malicious?
Not that we were able to find. We were able to find it in the very case that Adelaide stated, which is Khan. And then Khan specifically is a case where the appellee actually had to receive therapy, psychiatric therapy, after suffering substantial emotional distress. That didn't happen here. Yes, there were incidents of maybe uncomfortable contacts, all of which were very respectful in an attempt of Mr. Cohen to salvage the relationship, but none of them were hostile.
So the trial court's finding, when a trial court makes a finding of substantial emotional distress in that statute, it's based on the live testimony they received in court, right?
Correct.
And something we have to defer to the trial court's findings on?
And I'm glad you mentioned that because there's a specific part of the appellee's testimony during cross where I asked her, would you agree that most of, if not all of these texts were sad in nature? She says yes. Counsel for the petitioner at that time actually argued in closing argument, I believe, that it was a subjective feeling that she was feeling.
Counsel, we just established, we're not looking just at the text, we're looking at the whole course of conduct.
Right.
If she said to each one of these instances, that specific instance did not cause me substantial emotional distress, that does not mean overall they couldn't, right? And the trial court looks at that based on live testimony. Trial court got to look the opponent in the eye, got to look your client in the eye, and the trial court decided there was substantial emotional distress. We don't get to take any testimony, right? How are we supposed to decide the trial court was wrong to find that substantial emotional distress can be caused when it's fully based on the evaluation of witnesses that we can't do?
But even if it found that there was substantial emotional distress, it has to find that there was maliciousness in those contexts. And we would argue that in none of these contexts was there any type of maliciousness. Yes, there was an attempt to salvage the relationship.
So I see in the statute, I see maliciousness listed under cyber stalking. I don't see it listed under harassment. For harassment, it just says engage in a course of conduct which causes substantial emotional distress and serves no legitimate purpose. There's no maliciousness requirement in the harassment problem, only the cyber stalking.
Which is why we refer to case law, specifically the Khan versus Richmond, which I believe cited. And it specifically says malicious behavior goes beyond intent to cause injury, behavior that's without just cause or excuse. There was just cause. He was, heartbroken.
I guess what I'm saying, we've established, we're really focused on the language of the statute,
Yes.
right? The harassment problem doesn't say anything about maliciousness. Cyber stalking does, harassment doesn't. The statute contains no requirement for harassment that the behavior be malicious, does it?
I did not see that in the statute, Judge, which is why, again, I want to refer to case law to see if there's any shedding of light in that respect.
If another DCA said harassment required malicious, that would be something they injected into it. It's not, you're looking at the statute, do you see it there?
I do not, Judge.
Okay.
But
So would that mean if another DCA said it required maliciousness, that they added that onto the statute?
I'm sorry?
If another DCA said that conduct to constitute harassment had to be malicious, wouldn't they have added that onto the statute?
Possibly, Your Honor,
Okay.
but based on the two prongs that are necessary, substantial emotional distress by a reasonable person, we would argue that there was no substantial emotional distress and there was a legitimate purpose.
Well, Counselor, let me just say, I would disagree, and this is broadcast and recorded for the public. I would disagree with the idea that if someone specifically tells another person that they don't want any further contact, that does not, there's no case in Florida that gives that person that's been clearly told to stop, don't contact me, don't contact me. There's nothing in Florida case law that gives that person the right to continue to pour on contact. There's nothing that does that, because eventually, counsel, it does become stalking. It does become stalking when someone shows up at your place of employment, confronts you when you're out with your friends at a club, follows you to a parking lot, stays in the elevator so you can't use the elevator and have to use the stairs to go to your car. And we didn't even get to the fifth incident, which is that same night after Ms. Turner says the elevator's doors open, he gets on the elevator, they close, the doors open again. Then I said to him, I start yelling, leave me alone, just leave me alone, please leave me alone, I don't want to talk to you. This is substantial emotional distress. We don't judge it by a subjective standard, but if it were, this is clearly it. But even if it weren't, objectively speaking, consistently following somebody, not allowing a person to get into an elevator, grabbing their arm while they're trying to leave a club with their friends after you've been told to leave the person alone. And then the icing on all the cake, he shows up at her house that night. He comes once again after he's been told, leave me alone, leave me alone. You can't put a Band-Aid over all this and say that, well, love heals all, love makes it all right. It does not, and I don't believe there's case law out there that state that.
Well, again, Judge, Ravitch versus Wheelan, 50 CA case states that.
I'll take a second look at it. I don't think that's what
And
it
in that
says.
case, the court resolved that considering appellant went against the appellant's wishes of no contact and he continued to contact her, the court in that case did not conclude that that was an act of stalking.
Respectful, possibly a letter, maybe a flower here and there, but not showing up to their place of employment, not going to their house in the middle of the night, not grabbing their arm when they're around their friends. But counsel, I'm going to give you 30 seconds if you want to just wrap up. I know we've asked one question.
Judge, I think another case that we got cited in our initial brief that I think wraps up summarizing this case, and I believe it's on point. This is Randolph v. Rich, which is cited by Williams v. Jones. The law requires more than general relationship problems and uncivil behavior to support the issuance of an injunction.
Counsel,
Was
to
it
have a
uncivil?
relationship problems means there was a relationship.
There was a relationship.
Okay, did there continue to be a relationship after she said, I don't want to talk to you anymore?
No,
Okay, so there wasn't a relationship when these things happened, weren't there?
no, but there was a relationship before. There was a history behind this,
So these were not relationship problems because the relationship had ended, right?
which, as the case Randolph v. Rich states, uncivil behavior. We can say that may have been uncivil behavior, but that case specifically resolves that even though it's uncivil behavior, it doesn't rise to a level of stalking.
I'm going to go, I know we're just going back and forth on this. Thank you, counsel.
Thank you.